For the record, my name is Jerry Allen. I am a lawyer from Goldsboro, and I represent physicians in medical malpractice cases on a full-time basis. That is a career path that I chose a long time ago. I'm in my 19th year. I spend an awful lot of time with physicians in the context of medical malpractice, and I'm here primarily to speak about that today. First of all, I would say to the board that I do disagree that all medical malpractice payments should be posted. I noticed, first of all, that the statutory mandate says that this information shall be provided or made available to the public. However, the statutory mandate does not require, for example, the posting of medical malpractice payments on the website. That is a very important distinction between the statute and what is proposed in the rules which are before this room and the public now. There is no correlation, real correlation, between medical malpractice payments and settlements and standard of care. The Federation, in fact, said this, quote, "A number of studies have been conducted to identify indicators of substandard care among physicians." It went on to say, "There is no conclusive evidence that malpractice data correlates, with professional competence. A payment and settlement of a medical malpractice action or claim should not be construed as creating a presumption that medical malpractice has occurred." Now that's the statement of the Federation in 2000 when it proposed physician profiling. I would contend to the board that we still have no evidence to indicate a correlation, a real correlation, between standard of care or quality of care and settlement of medical malpractice cases. It was true when the Federation said it in 2000, and it is still true. I also want to point out this. As a lawyer representing physicians, and I've had this conversation with members of the board already, we come to a certain point in a malpractice case when I have to sit down with a physician and I have to have what I call an informed consent discussion. That is, I have to talk with that physician about whether that physician ought to consider consenting to settle and settling the case. That is a very important moment in a malpractice case. Now, already, before you even put these rules out here, there are a number of impediments to obtaining consent from a physician. And these are real-world impediments. First of all, there's already the requirement that these payments on behalf of individual providers be reported to the National Practitioner Data Bank. That's already a concern that the physician has. They come to the table with that concern. They also have a concern about the potential impact that settlement will have, for example, on hospital privileges and other privileges. A real-world concern that the physician has. The physician is concerned about the board's investigation already of all settlements of medical malpractice cases. Now, we agree that that is something that the board must do. But nonetheless, you have to understand that the fact that those settlements are being investigated by the board impacts the decision of a physician to settle or not to settle. Another real-world impediment to consent to settle. They also worry about what effect a settlement will have on their malpractice coverage costs. Another real-world concern that the physician has. Now, I bring the physician into this informed consent discussion with those very concerns already existing.
4 minutes.
Thank you. Now we have additional concerns. Additional concerns have been expressed throughout this hearing today, and they are real concerns. If the rules as proposed are adopted, I believe that it will negatively impact the ability to settle malpractice cases. You say, how do you know that, Mr. Allen? Well, because I'm one of those who sits there and has this informed consent discussion with the physician, and when I finish explaining all these potential issues to the physician looks at me and says, what do you think I should do? Do you think it's in my best interest to settle this case, or do you think we need to go to trial with it? That's how I know that there will be a real impact on the physician's decision to consent to settle, because not only do we have the pre-existing impediments, we now have these additional impediments that these proposed rules, as drafted,
5 minutes.
will place upon the physician. There are a lot of unintended consequences that come with these proposed rules. Somewhere there's a saying about there's a road paved somewhere with good intentions. And I would contend that the road is paved not only with good intentions, but with unintended consequences as well. Thank you very much.
Thank you.